I apologize, Your Honor. I just need another chance. Serious,
Then why
Your
did you
Honor.
continue to do it?
I don't have a reason as to why.
I don't care.
I don't know. I just need another chance, Your Honor. Please.
Case number 25CR42638, the State of Ohio versus Dominique Sharp. Ms. Sharp is before the court with her counsel, Ms. Shy. Ms. Tranter, on behalf of the State of Ohio, we're here for a final probation violation hearing. Ms. Shy, does your client wish to have a hearing?
Your Honor, she's going to accept responsibility for the violations and waive the hearing.
Ms. Sharp, you understand that you are entitled to have a hearing.
Yes.
You wish to waive that hearing and admit to the allegations in the violation.
Yes.
All right, the court's going to find that you have violated the terms of your community control. Ms. Shy, I'll let you go first, or do you want me to go have Ms. Sharp speak first?
Then I'll speak first, and then I'll let my client have a word with the court. In addition to her accepting responsibility for these violations, she has either completed or worked on the other conditions that she was ordered to do within the past 5 months. She is employed. She does have 2 kids at home. She has spent some time in jail.
You continue to violate my orders by contacting the person that got you into this, right? And I ordered you not. Where are you working right now?
I work at Arby's and I work at Popeyes.
Well, you're not working at Popeyes anymore. My understanding is you guys do cocaine right before you go to work.
Right. Well,
You're not allowed to do that.
and I understand. And I wasn't going to go back to Popeyes. If I were to be released, I was just going to do Arby's. But my parents had already told me that if I do go to prison, then I was going to be on my own. I wouldn't be able to see my kids, talk to my kids. I wouldn't have nowhere to go being released. I know that I violated my probation by still drinking and then doing cocaine and talking to Richard. And I apologize, Your Honor. I just need another chance.
What do you think when I say you're not to have contact with someone who's in the Department of Corrections? What did you think I meant by that? Did you think I wasn't serious?
No, I knew that you were serious.
Then why
Your
did you
Honor.
continue to do it?
I don't have a reason as to why. Honestly, I've been knowing Richard since we were kids.
I don't care.
And I understand. And I don't know. I don't have any friends. And Richard was literally the only person that I have talked to for the last 3 years. And I understand that you said no contact, but I don't know. I don't know. I just need another chance, Your Honor, please. I know what I did was wrong.
Who are you living with?
I stay by myself.
What's the recommended level of treatment?
Your Honor, she would be at a CBCF level.
Do you know what that is?
No.
CBCF is an acronym for Community-Based Correctional Facility. It is an inpatient, lockdown treatment facility. That's what I don't know that that's what they're recommending, but that's the next step level of care for you.
Okay.
All right. Ms. Sharp, I will, despite this violation, continue you on community control. I will require you now to complete a community-based correctional facility with any recommended aftercare. Once you've completed that treatment program, you'll be on electronically monitored house arrest for a period of 90 days. Again, I'm going to reiterate, you are to have no contact with the co-defendant in this case. You know who I'm talking about,
Yes.
correct?
Yes.
You are, when your probation officer asks to see your phone, you are to turn your phone over to her. You understand that?
Yes, I understand.
And she's going to be checking regularly because every time there's a communication with the Department of Corrections, those communications are recorded. Are you aware of that?
Yes.
So I'm going to have her check the Department of Corrections to make sure that you're not contacting him. And if I find out you've had one additional contact with him from this day forward, you're going to prison.
I understand.
I'm not going to allow this to continue. All right. Anything else, Ms. Tranter?
No, Your Honor.
Anything else for probation?
No, Your Honor.
Ms. Shy?
No, thank you, Your
All
Honor.
right. That's all.
Under Ohio Revised Code, Section 2929.15, a court supervising community control has authority to revoke probation, extend supervision, or impose additional sanctions once a violation is admitted. In this case, the defendant waived her right to a contested hearing and formally admitted to violating multiple conditions of supervision, triggering the court's full sentencing authority under that statute. The violations were not technical. The record shows continued drug and alcohol use and repeated contact with a prohibited individual incarcerated within the Department of Corrections. Conduct explicitly barred by court order. Under Ohio Revised Code Section 2929.15, subsection B, such willful noncompliance permits immediate imposition of a prison sentence. Instead of revocation, the court exercised discretion permitted by Ohio Revised Code Section 2929.16 and Ohio Revised Code Section 2929.1. 7. Modifying the terms of community control. The judge ordered placement in a community-based correctional facility, commonly referred to as a CBCF, a secure inpatient treatment program authorized for felony offenders who demonstrate substance dependence but remain marginally amenable to rehabilitation. This is not probationary leniency. It is structured confinement with mandatory treatment. Upon completion, the defendant will be subject to 90 days of electronically monitored house arrest, another sanction expressly authorized under Ohio Revised Code Section 2929.17. Enhanced monitoring of electronic communications was also ordered, reflecting the court's reliance on compliance verification mechanisms tied to Department of Corrections records. The warning issued from the bench was legally precise. Any future contact with the prohibited individual constitutes grounds for immediate revocation and imprisonment. At this stage, Ohio law leaves no margin for explanation, only compliance or custody.